is not a worker as contemplated under the Labour Act. So what that means is that if in the absence of the application of Section 17 of the Labour Act, the only way an employer will be entitled to rely on force majeure to terminate an employment contract is if a force majeure provision is expressly contained in the contract of employment. From my experience, you don't find many contracts of employment that contain force majeure clauses. I've seen very few, essentially executive management employment contracts for very high-ranking employees. So that's one option, declaring a force majeure to suspend the performance of a contract in circumstances where it is appropriately to do so, i.e. when a contract has provided for it, and when the event that the person seeking to suspend performance relies upon actually qualifies as a force majeure event. Typically, a force majeure provision will define events that will constitute force majeure. The second option that's available to parties to a contract under the circumstances that we find ourselves in. And I actually think that this is the one that parties should explore the most, and that is variation of the terms of the contract. Of course, any sort of variation will have to be by mutual consent. So whether it's a business contract, whether it is an employment contract, any party that feels the hardship of performance can invite the other party to agree to a variation of the terms of the contract. If it is a business contract that time is of the essence, parties may agree to vary the provision making time, the essence of the contract, to take care of the consequences of the pandemic. If it is an employment contract, parties may agree to vary the employment contract, to maybe, reduce employment benefits, reduce working hours, maybe, give employees the option of voluntary leave without pay, or indeed, the variation may result in any other arrangement that the parties consider suitable to their circumstances. So, and I think that this is what a majority of the employers are doing. They are, beginning to have conversations with their employees to say, this is what is going on. We're a law firm. We're not receiving new instructions. We're not earning money. We cannot continue to carry the burden of payroll costs indefinitely. So we want to have a conversation as to the best way to deal with this. Let us reach an acceptable arrangement to all the parties. So this is highly recommended. From my experience, this is what majority of the employers, including some of my clients that I'm advising, this is the option that they have chosen. Of course, there is a third option, which is the termination of the contract on the basis of frustration. Now, frustration is a common law doctrine that applies to contracts, including contracts of employment. And essentially, legally speaking, a contract is frustrated where a subsequent event has happened to destroy the fundamental assumptions underlying the contract. So if at the time that parties were negotiating and executing their contract, they had not anticipated an event, and then that event happened subsequently, and the effect of that event is to destroy the fundamental assumptions underlying the contract, then a party may be able to rely on the doctrine of frustration to terminate the contract. So talking about a contract of employment, for example, what are the fundamental assumptions that underlie a contract of employment? I think those assumptions will include, one, that the employer will be able to make work available to the employee to do, and B, that the employer will be in a position to do the work. Now, if as a result of COVID-19 and all the restrictions that have come with it, an employer is not able to make work available to an employee is not able to do the work, then arguably, and I'm choosing my words carefully, arguably, it could be said that the contract of employment has been frustrated. Of course, the party who seeks to rely on frustration to terminate an employment contract or a business contract has the burden of establishing before a court in the event of a dispute that the event that that party has relied on, in this instance COVID-19, qualifies as a frustrating event as a matter of law.
Okay, I'm sorry, Mr. Chukwuka.
Yes.
Can you hear me? So
I
want to put it out clearly for everybody. Please, if you have any questions to ask, so that this session is very interactive, you can actually make use of the chats, or you can raise your hand, right? And we'll, answer your question at the speed of concern. So please, if you have any question, I know he has been talking for a while now. So somebody had a question initially, and she said that it would be interesting to know what employers can do or not, because in Nigeria, our employment law is not strong or even really in existence. So how do you stop employers doing as they like? It almost seems like employment law contracts in Nigeria are not what the papers are written on. I don't know if you have any answer to that.
Well, I think it is correct to say that our employment laws are not fit for purpose. I don't think anyone can argue against that. The Nigerian Labour Act that applies to labor relations in Nigeria is a very old piece of legislation. I know that an attempt has been made through the third alteration to kind of address that challenge. If you remember, or if you recall, the third alteration to the Constitution, which established the jurisdiction of the National Industrial Court as we know it today, made some interesting has some interesting provisions, including one that empowers the National Industrial Court to apply and enforce international best practices. I have my views about the legal effect of that provision that empowers the NIC to enforce and apply international best practices. But the reality is that the National Industrial Court today has adopted a very liberal interpretation of that provision and has relied on that provision to, seek to import best practices in other jurisdictions in the settlement of disputes between employers and employees in Nigeria. Having said that, I stick to the traditional view that an employment contract is a contract, and that parties who enter into it will be bound by its terms. Of course, there's the argument that the employer and the employee in an employment contract are not on equal footing, and that the employee is the weaker of the two. So that more often than not, employment contracts are, drawn in such a way as to favor the employee. While there is merit in that postulation, I still believe that an employment contract being a contract, parties are bound by its terms. So, and for example, as I've already said, it will not be open to an employer to unilaterally vary the terms of an employment contract. It will not be open for an employer to say, oh, in the absence of a force majeure clause, in the event that frustration is not applicable, and without the consent of the employee, an employer will not be able to say, you know what, I've not been earning money, so I can no longer afford to pay you, so I hereby terminate your contract. If that happens, the employee will have remedies under the law. And that was why I said in discussing the options that are available, that the option that I most recommend is one involving discussions between the employee and the employer. That discussion will assess the genuine impact of COVID-19 and then enable the parties to reach an arrangement that's suitable to the circumstances of the parties. I don't know if I've answered that question.
Yes, I think that's well answered by you. So you can carry on.
Okay. So the last option I was going to talk about is redundancy. You can have it's not usual to have a contract of employment providing for redundancy. What you tend to find more often is the redundancy provisions in the staff manual, and those provisions, when they are contained in the staff manual, they are usually elaborate. They for the circumstances in which redundancy may be declared, and then if an employee has been declared redundant, what payments, if any, the employee is entitled to. But redundancy is a tool that's available to an employer in circumstances where, due to the employer's inability to gain work and gain revenue, it's become impossible for the employer to continue to maintain its payroll as it is. So in that event, where applicable, an employer may declare redundancy and then lay off some employees. It's important to also make the point that there has to be a basis for declaring a redundancy. And again, I know that the Labour Act, I can't remember the exact provision now, makes a provision on redundancy, and sets the standard to be followed and even the procedure to be followed. So, for example, the Labour Act, I think, prescribes the principle of last in, first out, when an employer seeks to lay off employees for redundancy. So that's clearly an option that's available. There are interesting legal issues around redundancy, one of which is if an employer has exercised its right to declare an employee redundant and certain payments are made to that employee. Such payments may be contractual. They may also be ex gratia payments. The question then is, if that employee is subsequently recalled, will the employer be entitled to recover redundancy payments made? My view is that the employer will not be able to do that unless there was an express agreement between the employer and the employee at the time of redundancy. So these are some of the options. The only other thing I would like to talk about is, and again, I think this somewhat ties into the option about negotiation and variation. What I've also seen a lot of employers do at this time is to ask their employees to use this period of lockdown and sit at home, to enjoy their annual leave. Again, it's not something that the employer can impose on the employee, but through mutual agreement, an employee may agree to, because this is actually a period of downtime, and it will make sense if all of this blows away in July or August. An employee comes and says, I want to take my annual vacation. So I've seen organizations, have conversations with their employees and try to encourage them to actually take their annual vacations at this point, so that when all of this blows over, they come back to work, there won't be any need for them to leave work, because they want to take a vacation. So these are my thoughts. I would like to, I'll be grateful for comments and questions that will drive further discussions, if any. Thank you very much.
Okay, thank you very much, sir. We really appreciate this this talk. I mean, taking out time from your schedule to come and talk to us, we're really very, very grateful. So we have another question, right, from one of us. And he said, given that force majeure clause covering a pandemic in many employment contracts. Okay, sorry, let me take that again. Given that force majeure clause is absent in most contracts, what legal levers do employers have to resolve this type of situation?
I thought I had addressed that in the options that I discussed.
Okay.
So there is the option of negotiation and variation of the contract. There is the option of termination as a result of frustration, provided that the employer is able to satisfy a court or tribunal that COVID-19 operated to frustrate the contract. And of course, there is also the option of redundancy. I think those were the options that I discussed. All those options are available to an employer. In appropriate circumstances, I must add.
Okay. So someone asked again. I wanted to ask how all of this ties in with the employer's right to hire and fire. So Onye, so someone is saying, so how all of this ties to, no, this is not a very complete question. So I think I want to just unmute her so she can just ask her question so that we can understand what she's saying. So just give me a second so I can just find her. So, Onye, can you hear me? Can you hear Onye? Hello, Onye. Okay, maybe she's not close by. But I don't know.
But I think I have a sense of what the question is about.
Okay.
My understanding of the question is, so everything that I have said, how does it sit with the contractual right to terminate a contract of employment? And I think that's a very good question, because many contracts of employment will have termination clauses. They will have provisions that say that either party can terminate the contract by giving a specified amount of notice, or if it is, or by payment of making a payment in lieu of notice. So on that basis, regardless of with or without COVID-19, a party to an employment contract may terminate that contract by giving the sufficient amount of notice. There's no doubt about that. But what we're beginning to see from the NIC jurisprudence, and again, all of this flows from the NIC's interpretation of the term nutrition that empowers it to apply international best practices. We're beginning to see the NIC give decisions that suggest that even when exercising the right to terminate a contract, that that termination must be for cause. You know, under the common law, the principle was that an employer can terminate for a good reason, for a bad reason, or for no reason at all. That's the law as we used to know it. But I have seen some decisions of the NIC that have departed from that principle of law as we know it, relying on the provision of the third alteration that empowers the NIC to apply best practices. And the NIC is now saying that you cannot terminate for no reason at all, and you cannot terminate for a bad reason, that you have to give a reason for termination. So subject to that new jurisprudence coming out from the NIC, the law has always been that an employer can terminate for a good reason, for a bad reason, or for no reason at all.
Okay, thank you very much. Thank you so much, right? So Chief has a question. He's okay, he has put down his hand. Okay. Does anyone have a question at the moment? Tokumbo, do you have a question for us? Okay, okay. So I'm scrolling through the questions, and let me see who has any Okay, so we have a question from Vincent. He's saying, is it proper for an employee? Okay, Onyinye has acknowledged your answer, and she said, do you think that relying on the pandemic would be a good reason to terminate? Well,
to do what?
Relying on the pandemic. Okay, she said, do you think that relying on the pandemic would be a good reason to terminate?
So I think that it will depend on the specific circumstances of each case. So one of the options that I discussed is frustration. And if an employer purported to terminate a contract of employment on the basis that the contract has been frustrated by the pandemic, a court will take into account a number of factors in determining whether or not that termination was right or wrong. One of the factors that I think a court will take into account is the length of the lockdown necessitated by the pandemic. So if, for example, by next week or 2 weeks from today, the lockdown is lifted and we all go back to business as usual, it may be a lot more difficult for an employer to justify termination on the ground of frustration. But let's say that the lockdown continues for a period of 5-6 months, you know, and an employer is not gaining new business. The employer is not able to access its offices to do work. The employees are not allowed to leave their homes to get to their offices to do work. Maybe the nature of the work that the employee is required to do is not one that can be done remotely. Under those circumstances, there may be a strong argument that the contract of employment has been frustrated. So my answer to the question will be, it will have to be treated on a case-by-case basis. There's no one-size-fits-all. If termination happens on the basis of redundancy, and the matter gets to court, the court will want to know whether forced redundancy is something that's provided in the contract of employment or in the staff manual, whether the procedure for declaring redundancy was followed, and all of that. So those are the factors that the court will take into account in determining whether termination for any of the reasons I enumerated was right or wrong.
Okay, thank you very much. So we have another question. I think I'll just unmute the people that are asking a question. So this is from Obiako. So let me just unmute her. You can ask her question directly to you. So, okay. So Obiako, you can go ahead and ask your question. Hello, Obiako, can you ask your question? Okay, I don't know whether she's far from her phone or...
No, sorry.
So
I was actually sending someone's question, not mine. The person is Galaxy.
Okay.
Galaxy, yeah, so you should ask the person. Galaxy A50. I'm not sure who the person is.
Okay, so Kelvin Ofe has a question. So I'm going to unmute you, Kelvin, so you can ask your question. So Kelvin, you can go ahead and ask your question.
Okay, thank you. So what happens to a salesman who loses a contract or who loses a client due to the pandemic? Let's say the person sells data to a big corporation, and then because of the pandemic, nobody goes to work again, and then the client decides to, enforce the force measure, and then he loses the business. What happens to that particular employee if the company decides and say, okay, we don't get revenue from a business anymore, so how do we now continue to pay you?
No, say that again.
I mean, if a salesperson loses a client, due to the COVID situation, and then the company can no longer pay the salesman because there's no revenue coming from the customers or the clients which he currently manages. How does the employee now fight to retain his job in that situation?
So these are specific instances, but the options that I discuss will apply to these specific situations. Because your question is not different from a law firm that loses all its clients, So let's say that a law firm specializes in aviation law, right, and has 90 to 95% of its clients as airlines. I'm sure you have been reading the news about what's happening to the aviation industry. So the law firm is not getting any work, and then it's not in a position to continue to pay its employees. Again, the solution will lie in any one of those options that I discussed. That employer may decide to engage its employees to say, this is our reality today. All our clients have left us. We're not making money. We cannot continue to pay. We want to vary the contract of employment to provide for suspension of the employment pending when this whole thing is over and we start to make money. Now, if the employee agrees to that, then there will be a variation of the contract on a mutually acceptable basis. If the employee says no, I don't give a hoot. I don't want to know whether you have lost all your clients. The only client you have is not my business. You must continue to pay me. Of course, the employer will be forced to look at all the other options. So the employer will say, okay, is it an option to declare redundancy? If it is, that's what the employer will do. If it's not an option, can I be said that in the circumstances, the contract of employment has been frustrated? If it has not been frustrated, is there a force majeure clause in the contract? So at the end of the day, it will still go back to those four options that I discussed. Whether it is a salesman who's lost the sole contract that sustains its business, or a law firm that has lost the majority of its clients, it doesn't really matter. At the end of the day, it will have to be one of those options. And the employer will have to think carefully to be sure that whatever option it is implementing is the one that does not open it up to liability.
Okay. So Kelvin, does that answer your question? Kelvin?
Okay, thank you. I was chatting to unmute me. Okay, so finally, what happens when the employee is not contacted for a discussion, and then he just receives a letter and says, sorry, we can't continue to operate this contract because of the situation at hand? What happens at that situation? How does the employee now, seek for further discussions to regain his contract and all of those?
So I think one of the first things I said is that it is not open to an employer to take unilateral action on the basis of the COVID-19 pandemic. Any action that will be legally justifiable will be the one that is located within the four options that I discussed. So to answer your question, on the assumption that the contract of employment does not have a force majeure clause, and COVID-19, as of today, does not rise to the level of an event that can frustrate a contract, and then there are no redundancy provisions. If an employer fails to negotiate with an employee and takes unilateral action to terminate the contract of employment, of course, the employee will have remedies to enforce in a court. I mean, it's the logistics of that enforcement at this time is a totally different thing. But on the basis that the employee is able to find his or her way to the courts, he will have a good claim against the employer.
Okay. Thank you very much. I guess Kelvin is satisfied with your answer. So we'll move on. I think the house really gets in. People are asking a lot of questions at the moment. So let's move to, okay, Vincent has gone offline. Hold on. Okay. Chukwuka, let me see. Okay. Mute Chukwuka.
Okay, Stanley, thanks.
Okay.
Chukwuka, thank you for your presentation. I have a question. One, what if you have a discussion with your employee and try to make that offer, employee disagrees? I think you've touched on it. And then secondly, what if you have a modified contract, present to an employee and he or she signs, and then turns around, maybe part of the terms is to take a lower, a pay cut for the duration. And then the person comes back goes down the line and says he or she signed under duress. That's my second question. The third question is, how enforceable are these laws or these regulations? NDIC, what's the turnaround time for cases? Like if employee or employer takes a case, how long does it take, to come out? Thank you.
Thank you very much. Your first question, I think I've answered, yes. Which is essentially what happens if an employer attempts to negotiate with an employee, and then the employee rebuffs the employer. That will push the employer to consider other options that are available, whether to suspend, terminate for frustration, or even terminate under the general terms of the contract of employment. Your second question, which is an employee signs a varied agreement or contract, and then comes back to say that he or she signed under duress. Of course, the burden of proving that that signature was made under duress will be upon that employee. And unless in reality there were elements of duress, I don't see how that employee will be able to prove duress. The burden will not be on the employer to prove that there was no duress. The burden will be on the employee to establish that there was. Your third question, which is the length of time for the settlement of disputes at the NIC. I have to say that the NIC is one of the most efficient courts in Nigeria today. I do a lot of work before that court, and I've been very impressed with the way adjudication is managed by the court, whether it is in terms of notifying litigants and their counsel electronically for any changes in dates, or the expedition with which matters are conducted. Although we're beginning to see a slowing down of turnaround time in that court, and I attribute that to the increasing number of cases that are coming before that court. If you ask me to put a time frame to it, I would say that the average turnaround time will be between 1 year and 18 months. It could be less, but I'm talking about on the average.
Oh, okay. Okay, thanks. You've addressed all the questions.
Okay,
Thank you, Stanley.
Okay, thank you very much. So we have another question from just give me a second. Let me go through. Chigozie Ekwonu. So I want to take him off the mute so he can ask his question. Okay, the floor is for you.
Okay, hello everyone. So my question goes as follows. So assuming due to the pandemic, an employer decides to reduce an employee's salary, even though the nature of the job that the employee does is one that can still be fulfilled completely while working remotely. So can the employee decide to do something, maybe take it up against the employer in this case?
Yes, again, I think I've touched on that question. And what I said was that it is not open. It doesn't matter, actually, whether the work that an employee is doing is one that can be done remotely or not. It doesn't matter. If an employer is not suspending pursuant to a force majeure provision, and it is not terminating on the basis of frustration, and it is not terminating on the basis of redundancy, in the absence of discussions and agreement with an employee, it is not open to an employer to unilaterally reduce the wages or the salaries that are paid to an employee. It is not open to an employer to do that. And one thing that I omitted to say when I made the presentation is that it's advisable for employers, once they reach an agreement to vary the terms of a contract of employment, to, for example, reduce salaries, it will be in the interest of the employer to notify the relevant tax authority, other statutory agencies, and even the pension administrators. Because, of course, you know that under the payee scheme, pay-as-you-earn scheme, the personal income tax that's deducted from the emoluments of employees is a function, a percentage of the actual amount paid to those employees. So for accounting purposes, if there has been a discussion leading to a variation which results in the reduction of salaries, it will be in the interest of the employer to notify the tax authority, the pension fund administrator, and any other relevant statutory agency.
Okay. Okay, thank you very much. So yeah, so on to, I think we'll just take like 3 more questions and we'll round up. So we have a question: how can it, by Galaxy A50, how can it be justified when an employer asks an employee to proceed on leave without pay during the lockdown period, and then later declines the proper annual leave due to the employee when work reopens? I'll take that again. How can it be justified when an employer asks an employee to proceed on a leave without pay during this lockdown and then later declines the proper annual leave due to the employee when work reopens? You get that?
No, you were breaking. I didn't get that.
Okay, can you hear me now? Am I clear now?
I can.
Okay, so the question was like this: how can it be justified when an employer asks an employee to proceed on annual leave? Sorry, let me come again. How can it be justified when an employer asks an employee to proceed on a leave without pay during this lockdown, and later, when the lockdown is off, when the employee proceeds on annual leave, the employer now denies or declines the request? I don't know if you get that.
I mean, whoever asked that question obviously did not understand what I said. I never gave that as an option, and I don't think it's justified. What I said was, it could be an option, of course, with the consent of an employee. It can be an option to say to the employee, now that there is the lockdown induced by the COVID-19 pandemic, can you take your annual vacation during this period, so that when all of this blows away, you don't have to now go on vacation again. Of course, in that scenario, if the employee agrees to take his or her annual vacation now, it will be with pay. It's not going to be without pay. So that's definitely one option. A second option is to say to an employee, because there is no work that's going on now, do you want to just take a voluntary vacation without pay? And I made it clear that that can only be with the consent of the employee. If the employee says, no, I don't want that option, the employer will not be entitled to enforce it. So there are two separate things. There's a discussion between an employer and an employee. Because at the end of the day, we need to understand that this whole thing is real. It's not theoretical. I know colleagues, legal practitioners, who are employing lawyers. Since the shutdown, they have not received a single instruction from any client. They have not earned the pay continues into May, June, July, August. A time will come when the employer will have to have a conversation with the employee to say, this is the reality. How do we deal with it? And then both the employer and the employee may agree to an arrangement that works for everyone. So the employee may say, okay, we have not been doing any work for the past 5 months. I understand that there's no revenue coming in to the firm. So I'm happy to just stay at home until all of this is over, or I'm happy to be collecting 50% of my salary or 75%. It's all about negotiation and agreement and consent. But the truth of the matter is that sooner rather than later, parties will have to have these discussions if this lockdown continues into the foreseeable future.
Hello, okay, good evening. Sorry, I'm just assisting Stanley because of the bad network. So I believe we have 2 more questions. So I will read out Christine's question. Her question goes thus. Okay, so some companies have abruptly terminated their employees' contracts. Is it safe to assume that they may recall them when the economic conditions improve? Is it safe to renegotiate new terms that call for a more ironclad agreement to mitigate against a similar event in future? Did you get that, sir?
Yes, I did.
Okay.
So if an employer has terminated and the termination is not in accordance with, so what is not clear from the question is whether the termination is in accordance with the contract of employment. On the assumption that it is not, I've said repeatedly that that employer will be liable to the employee. Now, whether that employee can be recalled or not is purely a matter of agreement between the parties. And if the employee is recalled, to the extent that the employee can, I think I did mention that the problem with contracts of employment is that more often than not, the employee is negotiating from a position of weakness, but to the extent that an employee can, it's always advisable to, put or insist on contractual provisions that safeguard the interest of the employee.
Okay, thank you. The last question, Chimezi, I don't see your question, and because we've run out of time, we'll just take the final question, which is by Ifani. Ifani, would you like to read out your question, or should I go ahead and read it?
I think I can read it out. I can read it out. Thank you very much, Isom. Thank you so much, sir. So my question is, where a party to a contract and or an employee is displeased with the termination of the contract, how, in your own opinion, would you advise the employee or the party to proceed?
Sorry, if I say that again, I missed part of the question.
Okay, sir. I said, sir, that where an employee or a party to a business contract is somewhat displeased with the termination of his or her contract, how, in your opinion, would you advise such an employee or a party to proceed?
I mean, what I'll recommend is obviously that party that's aggrieved will need to retain a lawyer, possibly get a legal opinion from that lawyer as to the unlawfulness or otherwise of the termination. And if the legal opinion concludes that the contract has been unlawfully terminated, of course, a letter of demand should be written, and if it's not honored, the only option available will be to take the matter to court.
All right, sir. Thank you very much, sir. That accurately answers the question.
Okay. Sorry. Okay, sorry. Just one last question. Chiemezie, can you please take your question? Stanley, I don't know if you've been able to unmute Chiemezie. Please take your question quickly.
Okay, thank you very much. Thank you, Chukwuka. Just a clarification, please, a quick one to pose. So when you were discussing the section 17 of the labor law in Nigeria, I know you mentioned something about the definition of workers as artisans and all of that. So I just want to confirm, did I hear right? Or where does it leave the other categories of workers? So a follow-up to that, sorry, is that, so if that law does not categorize the other levels of workers, right? I also thought you discussed the NIC in details. So does NIC rely on those laws, or do they apply their own laws in their own dealings?
Okay, so you heard me correctly when I said that worker under the Labor Act refers to persons who do menial work, menial and clerical work. A worker is not defined to include professionals like lawyers, medical doctors, and what have you. So the consequence of that is that those provisions of the Labor Act that relate to workers as defined under the Act will not apply to professional contracts of employment. What the NIC will do in those circumstances will be to apply, enforce the terms of the contracts of employment, the terms of any applicable staff manual, and then with the enactment of the third alteration now, the NIC will also apply international best practices.
Okay, thank you very much, Chiemezie. I would like to say that any other questions should please be sent in. They will be forwarded to the speaker to answer directly. Over to you, Ifeanyi. Thank you, Mr. Chukwuka.
You're welcome.
Ifeanyi, please, over to you.
Yes, thank you, Chisom. Thank you so much, Mr. Chukwuka. You have been most gracious with your time and with your knowledge, and we are deeply grateful for that. I would like to summarize, if I can, all what has been said this evening. A lot, as we would agree, has been said. So for those who probably joined in the middle of the session or at the end, or just for those who want a summary, let me try to summarize all that has been said. So Mr. Chukwuka started with the general nature of employment or business contracts, talked about the labor law, the fact that the labor laws as it stands now only provides for workers, and workers will be defined now to mean clerical or manual workers. So professionals and all those rendering services that will not come under clerical services or manual services would not or are not governed by the labor laws and would therefore fall back on their various employment or business contracts. So the speaker also said that in the circumstances that we find ourselves, this current pandemic, there are 4 options open to parties to a contract in determining how to affect the terms of their extant contract. So he mentioned the first one, renegotiation and variation of the contract. He mentioned force majeure. He mentioned frustration. He mentioned redundancy. And as well mentioned, suspension of the contract. And key point to note is that the contract must have made provision for these options before parties can take advantage of them. He also advised that employees at the moment can take advantage of provisions for annual leave so as to reduce company downtime. He also mentioned that termination of any contract must be in line with the agreed agreed procedure stipulated in the contract, and where an employee has or feels aggrieved for, in the opinion of the employee or a party, improper termination of his contract, then he or she can seek legal opinion to determine the next or the proper course of action. So, pardon me if I left out a lot, which I know I did.
Sorry. If I just want small clarification, I didn't say that all those 4 options must be provided for in the contract of employment before an employer can opt for any one of them. So, for example, the option of negotiating with employees to vary the contract, that doesn't have to be provided. It's just an option that's available. So that does not, again, frustration is not something that it's a matter of law. It's a common law doctrine, so it doesn't have to be provided. That's just the small clarification I wanted to make.
All right, sir. Thank you very much, sir. And of course, like you also said, where extant legislation implies into the contract any of these options. So, sir, we would love to thank you so much for your time. We know how difficult it must have been to make time out for us. We are honestly grateful. We can only pray that God's grace continues to guide you. We would like to plead that if you can't continue to extend this privilege to us, to reach out to you where we have further questions to ask, or if there is indeed a need to invite you back on our platform to also handle another session for us, we would pray that you extend your indulgence to reach out to you, sir.
That's not a problem. Like I said at the start of the session, I think that you guys are doing an excellent job. It's something that we all have to support. Please feel free to reach me whenever you require whenever my attention is needed, and I'll be more than happy to be involved. Again, thank you all for having me.
Thank you very much,
Mr. Chukwuka.
Over to you, sir.
Okay, thank you. And we've come to the end of this session. We would have the closing prayer. Ada, if you could please wrap up with the closing prayer. Stanley, could you please unmute Ada so that she can. Stanley?
Okay. Hi. All right. Thank you once again, Mr. Chukwuka. We appreciate you coming, and well done, PD team. We appreciate the time and efforts that you put out there. Hello, can you guys hear me?
Yes, we can.
Oh, all right. Okay, just a quick announcement to everyone, just in case you haven't heard. We actually putting out a short-term palliative to our members who really need some sort of assistance. Just reach out to any ESCO. Feel free. We're a family. I mean, no need to be shy about anything. If you're really pressed with something,